Good afternoon, everybody, and welcome to the November meeting of the Divorce Support Club. With me, Claire Macklin, a divorce coach, and today I'm joined by Natasha Alsop from Walker Family Law. Natasha, would you like to quickly introduce yourself?
Yes, thanks, Claire. Yes, so I'm a solicitor in the family team. So I do private divorce, children, finances arising from divorce, and living together issues such as cohab agreements and issues following separation. And I've been a solicitor now for over 20 years.
Brilliant. Thank you very much, Natasha. And as we all know, I'm a divorce coach. My role is to work alongside Walker Family Law with some of their clients to help them navigate the emotional journey through separation and divorce. And today we are going to talk about do I have to go to court? And this is something that comes up often when I first talk to clients. Often clients are really scared about whether they'll actually have to appear in a courtroom as part of their divorce proceedings. The whole divorce process is a really alien process for many people. Most of us don't ever want to really have to, it's not something you dream of when you get married that you're going to end up in a divorce court. And it's really scary and it can be really unknown. And most of my clients have no idea how it works from the start. And it can be quite terrifying. Your life is already up in the air. It's like a train is derailed and your life is some of it's fallen off the tracks and some of it's on the tracks, but some of it's been left behind and some of it's shot forward. And it can be really isolating and people can feel really lost. And I don't think the media portrayal of divorce in films and dramas and so on helps this at all. And those kind of fears can really paralyze people. So what we want to do today, I think, is give people information so that they have knowledge, because knowledge is power, isn't it? Gathering the information that you need can be really powerful to help you feel a little bit more settled. So there's probably going to be a lot more input from you from a legal side today than usual. But so my first question is exactly what the webinar is titled. Do I have to go to a courtroom to get my divorce?
No is the quick answer, but it's a lot more complicated than that. And it's right that most people have the same concern that they share with you that they do with us as solicitors,
Mm.
often when they first come in, or often later on when it may look like things can't settle. I think there's two branches of it really. That you might have to go to court in the sense that you have to write to the court and deal with everything on paper. So the court is involved. But I think what you're saying is more people are concerned about actually the idea of having to go into a courtroom, often as it's portrayed through the media, which might be very, it might be an acrimonious divorce, and the idea of going to court and seeing someone there and being in a big courtroom as it might be seen by other people is really daunting. But no, the answer is you don't generally have to go to a courtroom. Uh, More often than not, divorces that end up in court, as you'll often hear, I don't want to end up in court, are those which are very contested by either party or both. So it might be that one person's very amicable, but the other person isn't, or it might be that they're both just really contested on point, and they do have to go to court. But actually, those cases are very small. We always say a very small percentage, sorry, of our cases end up in a contested situation. And you'll hear most lawyers say, is it going to be contested or is it going to be agreed? And if it's contested right to the end, is where you end up having to go through to a final hearing in whatever area you're in. And that's when you end up in a court. But I mean, it's really difficult to put percentages on it, isn't it? But I'd say less than 80%. I mean, if I'm just guessing on my own files over the last 20 years, I'd say end up in that courtroom scenario that people associate with going to court. That said, if you're, I think the three strands, say you look at divorce, it might be, you've got divorce as one, you've got potentially you have children together and you've got that issue as another one. And then you've got your finances arising from that. If you're looking at all those three and they're three different things, and I don't want to get too broad, you might have to apply to the court and the court will be managing the process. So you are going to court in the sense that you're asking the court to assist you, but more often than not, that's done on paper. sometimes by consent, sometimes otherwise, but it's usually done on paper. But the
Mm.
three differences really do affect how you approach it.
Yeah, and I think that's something that a lot of people don't understand right at the beginning as well, is that the divorce process can be split into, like you say, three strands. There's the paperwork to dissolve the marriage, and then there's arrangements for your children, and then there's how you're going to divide your financial assets. Um, and lots of people don't really understand that those three things can they kind of stand separately, and alone,
Exactly.
but in the round as well.
Yeah, because you can't have a divorce without the court being involved. So I'm using the court being involved rather than going to court, because you are asking the court for assistance. But in a divorce, you have to ask the court to do that. And we now know that lots of people are aware that that can be done online as a paper exercise. But you're right. What often people will say, well, actually, don't we need to do something about our children? We're separating and we've got two children together. We're fine. We agree what we're doing. But don't we need to ask someone what we're going to do? Do we have to get it approved by anyone, what we're agreeing? Is there anyone that needs to know about it? And so that's a separate issue again, really. And actually, you can just go and have a divorce online, on paper, without having to go into a courtroom. And then the children is completely separate. The court doesn't really need to know what you're doing about your children unless you need some assistance. And in fact, the court in children matters won't get involved. They'll say the opposite. They'll say, we don't want to be involved. We don't want to have to be involved unless you require some assistance from us, and then we might need to be involved. So you can agree whatever you like between the two of you in respect of your children, and not then there's no obligation to let the court know that when you get divorced.
I think
That change from
people often think that the law sets out an answer,
mm,
and it doesn't set out an answer. You know, that how, particularly with the children, how you divide your time or how you share the care of your children together isn't mandated by any kind of law, black and white law, kind of process. Actually, it's understood that best thing really is if you can work it out between yourselves, on the basis of what's right for your family.
yeah, exactly. I think the financial implications might be different in terms of the
Mm,
provision for the children, whether you're divorced or not, financial provision. And in terms of the time spent
yeah.
or, communication between the two of you, it really is what works for you. And it doesn't really matter whether you've been married or not. It would be the same if you were unmarried, separating with
Mm,
children. It can be very individual. But I agree that often people do say, I heard that there's, that everyone now does 50-50, and that's what the court does. And it isn't like that at all. It's very much, um, try and sort it out yourselves. And if you need us, we're here. And actually, there's another strand now to the way in which children proceedings work, which means it's easier if you are needing some assistance from the court because you need a court order for some reason. Someone might be going to live abroad, or there might be some reason that you feel that you need some legal structure to your agreement, and you need to seek legal advice on that. But that can still be done by consent. There's a special provision where if you've got an order and it is necessary, the court does need to make an order. So it's not something that the court says we don't need to make an order in this situation. You can then do that by consent as well without going to court. That could be done by paper now. Well,
mm,
but there's an easier process to follow. So it's just about getting advice if you think there's something extra. But those situations are very unusual. 9 times out of 10, you can agree everything for your children without having to go to court. Obviously, there's
yeah.
differences and problems. Perhaps we'll come on to that later when you might have to go, but generally speaking, you wouldn't.
Yeah. And one more question on this. You've mentioned consent and consent orders, and I get asked this question a lot. What is a consent order?
A consent order, often what you'll see online is consent orders in financial proceedings. You'll see the reference to financial proceedings. But actually, a consent order is any agreement that you want to ask the court to record if they legally have the power to be involved, so if it's in relation to finances, children, it's any of those things. And you're right, actually, clients say, I want a consent order, but often what they'll mean is I want a financial order, recognizing what we've agreed. But actually, consent orders can be any of those strands. You could have a consent order within divorce for a particular reason within the divorce proceedings, like quite unusual. consent orders are in children. You agree what you want, and you might need the court's assistance, and you both agree, and that's a consent order. So any agreement that you have, which then becomes a formal court order, and you're both agreed on the terms, is generally referred to as a consent order. But
Yeah.
in finances, which is a separate strand again, so if you agree the finances of your of the if your marriage is broken down and you say this is what we would like to happen with our finances, and we need the court to look at that and approve that, that's then a consent order if you agree. And that's what you'll see online quite often, is that's what people are referring to, the finance consent order. But it's any of them really if you agree.
Yeah, yeah, that's really helpful. Thank you. Um, so I think big points coming out of there are that you can do all these things by agreement. When we talk about sometimes, going to court, it might be that, and most cases, it's literally a paper exercise, and your paper's being stamped by the court and approved by the court, rather than you having to go and stand in a courtroom and present your case or anything like that. And I think you said something like 80% ish
Yeah, I mean, this is
cases
my
in your,
guess, really, in terms of those what we call final contested
yeah,
hearings, where the idea in those are unusual, where you have to give evidence to the court, which is what you might associate with
yes,
going to court, being in a big courtroom.
yeah,
And actually, just on a side note, just to I always get asked this, if we do have proceedings, people say to me, oh, they have a vision of, lots of people in the court. It's a big courtroom like you'd see in a Crown Court or something, and it's not like that at all. It's much more informal as it can be in court. It's generally a small room and chambers with a judge, and it's very different to what you might see
mm,
portrayed in the media.
yeah, yeah, much more user friendly.
Definitely.
Yes. Okay, so moving on from there, um, there are clear downsides, I think, aren't there, to ending up in a courtroom that are very different to what you've just described. Is when you can reach agreement by yourself and you can draw up a consent order that just reflects that agreement and the court will stamp it. If you do end up in court proceedings, it's very different, isn't it? You're no longer really in control of the outcome necessarily. So
Exactly.
if you can do all you can to keep your divorce process on paper and to reach agreement, it's going to be much better in the long run for you. Because otherwise you're handing over control to a judge, a single person who you don't know, who doesn't know you, um, who's human like the rest of us, and who will make different decisions depending on their view and their perspective, I suppose. Um, so could you, before we go, we'll talk a little bit later about what kind of cases probably do need to end up in front of a judge. But what other options are there to reach agreement? So the next question I'm often asked is, well, how do we reach agreement on our finances or on our children? We're so far apart at the moment. I don't understand how we're ever going to get to a place where we agree. So what are some of the processes that people can use?
So we call this, there's alternatives to going to court. So in a general sense, we call it alternative dispute resolution. But there's also actually just simple as, you might just have a friend who wants to initially sit with you. It doesn't have to be that stage. But so the starting point might be, well, we want to sit down and we try together. That might be, some couples just say to me, we're quite able to sit down around a table, just the two of us, and try that and see where we get and see what we're left with, because we might be able to just narrow down the issues and what we've got left. We could agree this over here, but we still haven't been able to agree this. Other people say that's just not possible. We're just not at that point. As you say, they might say, how do I agree this? Because I don't even want to be in the same room at the moment, and I don't know how to do that. And once they've had legal advice, it might be then that they start by, a solicitor picking up the phone to another solicitor, or sending some emails, sending some correspondence. And that's what is often the start, just to see what kind of issues are between them and whether or not there is actually any agreement or capability of an agreement. And then there are more formal, I say formal, they are informal, but more routes, which we say, well, actually, we've got to the stage now. We've tried some letters, we've tried some chatting. We've still got these issues which we need to sort out. And then there are alternatives such as mediation. I think most people now will be familiar with that term. It's used across the board, not just in family proceedings. Um, Mediation is where you go to an appointment in all different forms. There's all sorts of ways you can do it, but it's generally with someone, a qualified mediator, facilitating that agreement then between you. So trying to reach agreement and trying to look at, again, what's left essentially, because often when you unpick it, you'll get nearer and nearer and closer and think, actually, we're not as far as we thought. So mediation is an option. If you have more discrete issues, so for example, in a finance case, you might have agreed quite a lot of it, but you just can't agree what's going to happen to the pension, and you want someone to make a decision, there's lots of ways you can also do that without going to court. So there are alternatives now. You could go into what we call a private FDR, where you appoint someone privately rather than go through the court process and a judge. You both have to consent to that. But if you agree to that, you could use that process. There are solicitors can have roundtable meetings. I'm a fan of them. I think they work really well. Solicitors say, okay, we'll all get together in an office for the afternoon and see if we can, go from room to room or all in a room together, and it can be exact, how you want, and you can decide together before you have that meeting what it will look like. Roundtable meetings are a good way. There's also, collaborative law as well. Some solicitors train specifically in collaborative law, and that's, again, both people have to consent to that, and they provide you with details about that before. Mediation is probably the most common route for starting if you want someone else to help you. If you think, actually, we've tried doing it ourselves, we've thought about, it might be a parent said that they'd help, they thought about all that and they haven't been able to do it, then mediation is a good starting point. And in fact, for at least 10 years now, it's been mandatory to try that before you go to court in certain cases, such as finances or children. So if you can't agree something, you do have to try and see whether there are any options available to you. And that doesn't necessarily mean you have to go to mediation, but you do have to go to what we call a MIAM assessment meeting, just find out a bit more about it and whether it's suitable for you or not.
Yes.
And that's a requirement which changed slightly this year. But so that's a lot of information all in.
It is a lot of information, yes.
Yeah.
And I know that Walker Family Law as well offer resolution together, which is a whole other new process that's
Yeah.
only been created in the last year or two.
Yeah. So we have quite a few of us here at Walker Family Law that do resolution together, which is where you both come in joint appointments and you are approaching it jointly, effectively, with the same solicitor. There's various processes before. We have to chat to you both individually, but if it's going to work, we will let you know that we think it will work. You can then come in together. It's not suitable for every divorce. It's probably a smaller number of cases that it's suitable for, but it does work for many people who know roughly what direction they're going in, but they just need to sit down and work out the legal aspects of it and what that's going to look like for them. And it's a really good alternative, but instead of having separate lawyers, that works for some people.
I think there's the big point here, I think, is there's a whole different range of options that may be suitable for you in your particular circumstances. Starting with a DIY, apply for your divorce online, right up to, a very contested divorce that goes to court. And in between those two things, there's a really large amount of choice as to how you want to progress your particular situation in your particular case. So I always encourage my clients right at the beginning to ask their solicitor for what are the different options that might be appropriate for us and in this particular, in our particular case. And one other question I get asked as well is it possible, and I think I know the answer to this, but is it possible to have the court involved in one aspect but not in the other? So, for example, you need to go to court to decide your financial split, but actually you can agree on the children and put in your own consent order on that aspect.
Yeah, largely they're all really individual. There's a slight crossover because if you agree something in your finances and you're getting divorced, in order for a judge to approve that, whether it's on paper or not, you need to have those divorce proceedings in place because that needs to get to a certain stage. So there is a crossover, but generally speaking, completely, you can have an agreement, you can have contested proceedings, because you really can't agree in one aspect, and the other you can say, actually, we've agreed all that, and we're going to have a consent order or just an agreement between the two of us in respect to the children or whatever it may be, and then
Mm.
still have they're not all together, they're not all bundled together in that sense
Yeah.
at all. And so that's an option for most people. Um, but yeah, just also to said on mediation about all the options, just thinking about it, is mediation itself. I know some people, yeah, there's so many options for mediation as well, which is why there is a necessity really now to say, um, you must go and explore it and find out about it and have an assessment meeting, because there's so many ways in which mediation can look as well.
Mm.
We have shuttle mediation where you're in different rooms. You might, and there's a different way, each mediator will have a different way of working that. You might have hybrid where your solicitors, your lawyers are there with you at the mediation, and you have a mediator and your lawyers there. So there's so many ways in which your divorce process may look in terms of the legal
Mm.
journey through it, really.
Yeah. And I think there are some mediations where the children can take part as well, aren't there? So there's all
There
sorts of,
are.
yeah, different varieties. It's not a one size fits all
That's
process.
really, and yeah, there's some really, really good mediators who have qualified in terms of mediating with children, and they either do it, there's family type of mediation that's available. There's, say you have a teenager who's 14, 15 and doesn't feel that they want to tell their parents directly, but is quite happy to go along to the mediator and have a chat with them about it all. And they can either, with their consent, can then relay that and say, actually, this is what they quite like it to look like. And they don't feel in an awkward position between either parents. That might work for some families. And as you say, Claire, I think it's really looking at, it's difficult. One size is not going to fit all. And so it just does depend on the individual person, the individual families, what it looks like as to which process will work for them. But yeah, mediation, they can work directly with children in the right circumstances.
Thank you very much. So, Natasha, that's covered all the kind of options where, for people to try to reach agreement. What kind of cases then are the kinds of cases that, in your experience, really do need to go through a court process, in front of the court, in front of the court and the judge?
Well, the first one is where you haven't been able to reach an agreement. So it might be very amicable in a lot of ways, but you just can't reach an agreement about the final points, or, how much someone's going to have from the house when it sells in terms of the money. And those cases, for a finance case, if you just can't agree and you've tried and explored all sorts of options, that might be one case which needs to go to court. In finances, particularly, there's also a situation where the court, if you have to issue proceedings in financial matters to resolve things, the court sets a timetable. So
Mm.
says you must by this time give your financial information. And then the next step, you can ask some questions on that financial information. And also, you might need to go off and you might need to get, an idea of how much you can borrow on a mortgage and those kind of things. Because the court automatically does that, with finances, sometimes you issue an application, you ask the court for assistance earlier on, so that the parties have really got some focus and some timetable to work from, and that can be really helpful in certain cases. So it's not always a adversarial process, going to court because you want to get to the end result. Is that the court, they need the assistance to get it moving and get it moving along. But actually, the other situations where you might want to go to court is where there's urgent injunction matters. So there might be domestic violence which needs an urgent application, and it must be made. There might be an urgent application required in finance proceedings where there might be, again, a type of injunction, to stop assets disappearing or something happening that needs to be done urgently. Often emergency
Yeah.
applications where you haven't got time to go off to mediation and explore all the options, you have to go and ask a judge or a magistrate's court, depending on which proceedings you're in, for some assistance.
Mm. Yeah. Yeah. No, that's really helpful. Thank you. So often, I think, in my experience, often some of the cases that end up in court are because emotions are running very high. The kind of people get stuck into perhaps a cycle of conflict with each other. So I thought it might be helpful at this point to just give some hints and tips in terms of strategies, sort of coaching style strategies that you can use um, to help keep yourself calm to suggest some strategies for communication that actually can help you in when you are looking at how you reach agreement, how you communicate with each other. And there are a few, I mean, we've had lots of webinars around this sort of thing before. So if you look, anybody who's watching, if you look back through a lot of the old, the previous sessions of this, we've done sessions on effective communication and we've done sessions on strategies to stay calm. So I just thought I'd highlight maybe two or three in this session. And one of them, I think, is something that you hinted at earlier, which is about taking your time.
Mm.
Take your time. You can take your time to make decisions. You can get all the information that you need in the background to be able to make those decisions in an informed way. So you might feel that you need a specific a bit of legal advice, or you might need to go away and, like you said just now, speak to a mortgage advisor. You might need to go and speak to a financial planner to look at the future of any proposal that's been put to you, and so on. So that's one thing. Take your time. You don't have to make rushed decisions. Um, you can take time and take the advice that you need. And I think there are some really important strategies in terms of staying calm through this process because, I mean, I know from talking to hundreds of clients over the years, when an email pops in from your lawyer, your heart rate kind of goes, and or an email pops in from your ex-partner or a WhatsApp comes in, and it can cause like a very visceral reaction in your body, and you go into kind of fight, flight, freeze, fawn response, where your body is reacting with sending cortisol, adrenaline, and it can quite easily cause you to make quite snap decisions um, through that kind of emotion. So there's two or three things that I'd really say to people. One is get your support team in place and make sure that you have people around you that you trust. That could include friends and family. It could include somebody like me, a coach like me, or a therapist. Definitely include a lawyer like Natasha, somebody to give you the legal advice that you need, and you might need a financial planner and so on. So build your support team around you so that you feel you have the support that you need. And then there's ways in which you can help to bring calm to your body. So when that kind of rush of emotion happens, the first thing I will say to people is to stop and breathe. Practice box breathing. Box breathing is incredibly powerful. So it's when you breathe in for 4, and then you hold for 4, and then you breathe out for 4, and you hold for 4. And you go round that cycle, just helping your brain to soothe. It will help to lower your heart rate. It will take oxygen into your brain, and it will help you to bring your logical brain back on side when your emotional brain has been really triggered. And then once you've got that calm, you can start asking yourself little questions. So things like, what can I control here? Because ultimately you can control yourself. You can control your responses. You can't necessarily control your ex, whether they're sending you a message, but you can control when you read it. You can control when you reply to it. You can control what you say when you reply to it as well. And I always say to people, it's worth taking 24 hours if you can. Take 24 hours, mull it over, sleep on it. Quite often, when you've slept on something and you look at it again the next day, it actually looks different. If you need to, take advice before you reply. So I speak to a lot of clients who feel that every time a message comes in from their ex-partner, they must reply to it immediately. No, take a breath, take a pause, think about where you want to get to. So one of the other things that I talk about a lot with clients is intention. Where do you want to get to? Where in 5 years' time do you want to be in your relationship with your ex-partner? And also in your relationship with them as fellow parent if you have children. And really bottom out exactly where you want to get to. And that can be really powerful to help keep you on track. I know when I was getting divorced, it was really important to me that when our children get married, we can sit at the same table if that's what they would like. I got divorced when my children were 1 and 3, so that seemed a very long time in the future. They're now 20 and 18, so maybe it's not quite so far in the future now. But that hope that we would be able to get there was very important in informing how I responded to things throughout the process. So work with a coach, with a therapist to help yourself get to that point where you know where it is that you want to get to. And the other thing I'd say is don't expect the court to be able to give you that emotional closure. that emotional closure needs to come from work outside of the divorce process itself. So that's where working with a therapist or a coach can be really, really helpful. So as I say, there is lots of information about all of these strategies in previous sessions that we've done, but they can all be really, really helpful. Take it one step at a time. Try and avoid the overwhelm by taking it one step at a time. And even things like what you were just saying just now, about issuing proceedings, sometimes to get a timetable in place. Sometimes if your ex-partner is particularly difficult or they're not forthcoming with their disclosure of their assets or something, that kind of thing can be really useful to give you a time scale that helps you to know what the next steps are and what's going to happen, because this is a time of such uncertainty. Any way in which you can find some certainty to hold on to is going to be really helpful, I think. And I don't know if there's anything that you want to add to any of that,
No, I
Natasha,
think
but
no, I think that's really helpful, and just not rushing it.
mm,
Often you can feel rushed by the other person in the divorce, but I think, or in a separation, whichever, whether you're married or not, and you've just got to take your time to look at all your options and see what's going to
yeah.
work first without being pushed into something that perhaps doesn't really work overall for you. Claire, I'm conscious that we've got a question,
Mm. Yes,
whether we
I've
should
seen
stop
the
now and then.
question.
Yeah.
Yeah. So the question, we can do that now, and we'll come on to our last couple of points, was about Talata. And could you explain what a Talata matter is, please?
Yeah, you often hear of Talata, and it's quite a long. Um, we shorten it down because it's the Trust of Land and Point of Trustees Act, and we say Talata for short. But what it means is often in family cases, when you hear the word Talata, it will relate to couples who usually are unmarried and they are looking at. We normally use it for property disputes in family. So there is a specific legislation that means we have to apply under that law, and that's what we all shorten it down to, and we call it Talata. So if you've separated from someone, you own a property together, you're not, generally it's unmarried couples because you can go through a divorce route. Not, you're unmarried and you can't agree what's going to happen to that property. Either it's owned in the other person's name, but someone has contributed financially to it, and they say, well, actually, I've got a share in it, or it might be owned jointly and you can't decide when it's going to be sold, or various other ancillary matters that arise as a result of that property. You'll hear solicitors, lawyers, you'll see it online. Oh, it's a Talata issue. Is your matter a Talata matter? And that's what they're referring to.
Brilliant. Thank you very much. I hope that clarified for our listener. Um, we 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 also wanted to. One of the other things we talked about when we were preparing for this was talking about cases when there is an imbalance of power between a couple, which I see a lot, and I'm sure you see a lot. Where, for example, it might be a situation where one person has been the higher or only earner and has had perhaps control of all the finances, while the other perhaps has had a lower paid job or has stayed at home with children, perhaps, or has supported that higher earner to succeed in their career. Um, and so, do those cases always have to go to court?
Um, no, I mean, they don't always have to go to court,
No.
but it's really important that the person who doesn't have all the information has all the information.
Mm,
So you often, I think we've talked about this before, haven't we? And it comes
yeah.
up so often. People
Mm,
say, um, I don't really know everything because, as you say, you weren't, you left it to someone else, or they
mm,
were the higher earner, and you just didn't get involved with all the finances, and you're really not sure, and you're not sure
mm,
whether you've got all the information. And the difficulty is that it's so common for that to be a sticking point at the
yes.
start, particularly, and then it kind of carries on through that you're not really sure whether you've got everything and you're armed with all the information to make a decision.
Yeah.
And
And
that creates
it can
difficulties. I think you
that
probably experienced that,
yeah,
haven't you, with your divorce
yes.
support?
Yeah, a lot. And it can arise for a variety of reasons. Sometimes it happens because that's what you've agreed within your relationship, that that's how it's going to work. Sometimes it can be part and parcel of a more sort of controlling element in the relationship, that there might be some elements of coercive control within the relationship. But it can be really frightening for the person who doesn't have that knowledge, who doesn't have that control. And I think, it's really important for us to remember, or for people to understand, that the divorce process itself has built into it this fundamental requirement for assets to be disclosed so that everybody discloses what they have, it's all put onto the table, and then there are negotiations around it. Um, and can you explain a little bit about the reasoning behind that for our listeners, if that's possible?
Yeah, I mean, it's really important for people to know what is on the table. We always talk about everything going into a pot, and the reason is to make sure that you're on equal footing. You know about everything in the pot before you agree to it, agree to what any settlement. But actually, if you're not wanting to go to court, you think you know what your financial agreement is. You think, well, it might be that I'm going to remain in the house. It's going to keep his pension. If you don't have that financial information and you go to a judge and you say to the judge, can you now please approve this in writing? We don't need to come to you, but here's what we've agreed. And that's in the consent order we talked about earlier. You've put it into to a judge and he or she is looking at it. They will say, I need to see a summary of your financial position. I need a long form that we have to hand in giving a summary. So the judge will need all that information. We'll need to see everything. We'll need to know if you've got a property in France. We'll need to know if you've got £5,000 in savings. We'll need to know if you've got £20,000 on credit cards, because the judge, it's not a rubber stamp. The judge has to look at it and decide whether that order is fair, and that if it's going to be approved and made by the court, whether it's in writing or whether you're actually in the building. So that's going to be required. But actually, the person who is deciding whether to accept that settlement needs to know everything to make sure it's fair for them. It has to be fair for both parties as much as it can be, and something that the court's likely to approve. But they can't make that decision. You can't possibly make that decision if you've got a little bit of the puzzle missing.
Yeah, something that I see fairly often, too often, is where one of the parties has given a proposal to the other, and has said something along the lines of, "This is my proposal to you. This is what I propose we do with all our assets. I've given you a schedule of all the assets. Here they all are on this spreadsheet, and this is my proposal. And you really should accept this now. Let's not go and talk to any lawyers, because I promise you I've done the best I can, and this is absolutely fair between us." And I see a lot of people in my coaching practice who have had that said to them, and then they're then afraid to push further and to instruct lawyers perhaps to have a look at it. And I always say to them, amicable, this is often
Yeah,
used actually in this context. The other person will say, well, I don't want you to instruct lawyers. I've given you this proposal. It's really great. You should accept it. And we've agreed we want to be amicable. So if you go and show this to a lawyer, that's not very amicable, is it? That will open everything up, and that will lead to all sorts of arguments. Now, I I see that as a kind of nefarious use of the word amicable. It's using amicable as a bit of a threat. It's using amicable as a bit of a threat of, you need to do what I've suggested. And if you go to lawyers, then you're not being amicable, and therefore this is not going to end well. Is something that I've heard quite often. And I think it's really important for our listeners, if you're somebody who's in that situation, there's a really lovely way that you can answer that by saying, look, amicable does not mean that you give me a proposal and I accept it. What amicable actually means is we both go into this process honestly. We both put our assets and what we have on the table, and then we follow the process, and we both take the advice that we need in order to ensure that our settlement between us is fair. And I have clients who have kind of learnt that off by heart and repeat it over and over again,
no, that's a good
to a
idea.
partner who's perhaps very pushy.
Yeah,
Sorry,
that,
Natasha, I interrupted you.
no, I was saying that's a good idea. I mean, from a legal point of view, by the time they've come in and it's so common. You're right. It's really, really common. This, oh, now you're going to make things all really difficult because you're taking advice. But everyone's entitled to make sure that they have advice and that they
Yes.
are fully informed, and that you'll hear this if you are in contested proceedings, that they're on an equal footing. That they have the information that they need to make an informed decision. Often, actually, it's the cases where the settlement isn't particularly good for the other person. Not always, but generally speaking, it will be a settlement that probably isn't going to be approved by the judge, or definitely isn't favourable, or isn't something they probably would end up with. And that's when they
Yeah,
put the pressure on and say, well, here you are, you've got it all. You don't need to go off and check pension details and check this. And actually, it's very difficult without the judge having the actual information. It's very difficult to make any approved order anyway. So what it tends to do is waste time and costs actually. But yeah, from an emotional point of view, for someone feeling that they're backed into a corner, I think, isn't it, and feel like they
yeah,
have to, if otherwise it might scupper the agreement, and
yeah.
that's the issue, and
Especially,
they're worried
yeah,
that it might
yeah,
scupper it.
exactly. Especially if you're talking about a relationship where one of the people, for whatever reason, has been in charge of all of the finances. If you're the person who's not been in charge of those finances and you're finding this frightening, um, then your ex-partner producing a proposal may feel quite comforting. I would advise people always to go and get it sanity checked, to go and take some advice from a solicitor, have a financial advisor look at it, and so on. And talk to talk to somebody like me or a therapist if there are aspects of the relationship that are perhaps coercive in terms of this position. But I think I just wanted to raise that today, rather than going into a huge amount of depth on it. That might be something for a different session.
Yeah.
But I think it's important for there may be people listening who find themselves in that position.
Yeah, and it's really important that you do have all the information, and it's just about your help in how the best way to get there
Mm,
without it doesn't need to become acrimonious, difficult. It's just like any other process in life. You check it first, you check all the information, then you'd say yes or no, or yes, that's fine, but actually now we've seen this, I think we might want to move it in a different direction.
absolutely. And
And it's
these are
fair. One person should
decisions.
be saying it's fair for that person to have all the
Yeah,
information, and if they're not, then that makes you question. First of all, people then feel that they can't trust that person because they don't know why they're saying it. And second, as you say, it could be more another level where someone's been coercive or controlling. I should also say, when I was saying about mediation and all the other options earlier, often they involve by consent, you both consenting to mediation, going together. But if there is an element of any kind of element of domestic abuse within your relationship, it might not always be appropriate. So even that would include if there's a situation where it's coercive controlling behaviour. We're getting off topic, but just to say that that's important that people know that, because so often people say, "Oh, I can't go to mediation because this happened and this was the behaviour or this was in our relationship." You still go and explore that, but the mediator will explain all that to you.
yeah,
That's the same with us doing resolution together. We'll do meetings with everyone just to find out the background of the relationship. You go and explore, but it doesn't necessarily always happen, and it might not be appropriate to happen if there
mm,
has. It often isn't appropriate.
yeah,
The imbalance of power might be to do with something much more. Often it's just a case that someone's just controlled it, as you say, because they've taken control and they've wanted to. There's nothing more than that. But there can be other reasons, and you need to explore that properly before you decide
yeah.
which course
Each
to go
case
down.
is different, isn't it?
Yeah, exactly. So
It
it's just a
really is
point that
different.
I probably didn't make earlier.
Yeah, yeah. We are coming to the end of our time, I think, now, Tash. I think there has been so much information in today's session, so much really useful nuggets of gold in there in terms of people understanding what process looks like. So thank you very much for explaining that all so clearly. Um,
You're welcome.
and so all that remains of you say thank you to you, and also then for everybody else. I think we're next month in December. I think we're talking about Christmas.
Oh,
Christmas is
really?
coming up. I can't remember the date off the top of my head, but hopefully we will see you all there next month.
No,
And thank
thank
you very
you.
much for coming
Thank
along.
you, Claire, and thanks for those that have joined today. Thank you.
Thank you.
Oh,